I'd like to welcome you all here again. This is the last of the series of 6 breakfast sessions. So I congratulate you on your courage coming out at this time of morning on this last occasion. You should have in front of you a paper, and this week there's a pen. Must be a celebratory present to end this, and also the yellow card that applies to this particular topic. Once again, we'll try and do a little exercise in the middle of this, so if you stay alert. This is a great topic, another micro topic in negotiations. The title is based upon a famous paper by Robert Mnookin in 1979. Most legal literature is published and disappears into oblivion in about 10 minutes, but occasionally there is a great article published, and Robert Mnookin published this article called Bargaining in the Shadow of the Law. And that has had a profound effect on how scholars think about negotiation and about the law. And so this copies from his title, steals from that greatness, Bargaining in the Shadow of the Tribe and Limited Authority to Settle. And the tribe's used in a sociological sense. If you read sociological literature, it's not referring to a particular ethnic group or anything like that. It's just a bunch of people in the background. So I'll walk you through the paper, and please follow those who like to read at the same time as listening, and I'll highlight some pieces and leave some pieces out. So on page 1, just to set the scene, even if we live in an individualistic Western society, it's rare for individuals to be completely isolated. Those of you who negotiate for mining companies or negotiate for clients know that they usually have in the background an influential person, a spouse, particularly in my world. Using spouses in negotiation is extremely important in my mediation practice. And that's a challenge for us as lawyers, because we're taught that we have a client in the West, and the client gives us instructions, and the people in the background are somewhat of a nuisance. But if you work in diplomacy or other fields, you know that the people in the background, the network, are very important. You'll see in the bottom of page 1, there are many names given to these people: the people in the shadows, the influencers, the bosses, the stakeholders, third parties, constituents, armchair critics, bush lawyers, sticky beaks, nosy parkers, that might be an Australian phrase, ratifiers, destabilizers, cheer squads, and very importantly, the concept of hawks, doves, and moderates. And so what to do about these people in the background is one of the standard bumps, one of the standard topics that a good negotiator has to deal with. If you look at the back of your paper, and on page 26 in the appendix, you'll see there's a catalogue of standard bumps, in the same way that a plumber would have standard bumps when they're digging a hole or putting in pipes. Here are some of the standard bumps that we've looked at in several of these classes. So the one we're looking at today is influential outsiders, or what lawyers sometimes call lack of authority to settle, which is a narrow kind of framework of looking at this. So classically, a dispute is characterized on page 2. You've got a diagram of disputant 1 versus disputant 2, plaintiff and defendant, classically in legal literature. But that's almost always unrealistic. Perhaps if your client's mentally ill and has no supporters at all, or is a totally isolated individual in society, that might be true. So more likely there is a group of people who are classically called, you see on page 2, hawks, moderates, and doves. And that language is very helpful. As a mediator and as a lawyer, that's been very helpful to me to categorize the supporters, because you need to work differently with those armchair critics in the background. So this is really pulling, if you want these definitions, they're in footnote number 1. Here are some rough working definitions. A hawk is a competitive member of a group who wants to win. They use the word win, which is generally an unhelpful word in life, at least not lose. And they use contentious tactics. They put down the other person, they don't turn up, they send them false information. A dove is a person whose major goal is peace and good relationships. So it's sometimes characterized as peace at any price, but it's not at any price because they're buying good relationships, stable relationships, and they'll give up a lot of money for that. And so they may yield. And then the moderate is the key to all negotiations. The moderate is the person in the background whose goal is to find an acceptable solution by give and take. So I'll give something and I'll get something. So they're the people, when you're shopping around for who to use as the key negotiators, look for the moderates and create a subcommittee of moderates. That's the basic tactic of good negotiators. Find the moderates and say, Bill and Mary, I'd like to have coffee with you one day to talk through this problem. Okay, they're the key because they won't give up everything, but they don't want to take everything. And the hawks in the old days, you'd assassinate them on the way to the meeting. You'd organize for a hitman to look after them, to look after loose ends, as they say. So you've got to get rid of the hawks. They've got to do your negotiations while they're on holidays. On page, you'll see on page 2, that diagram gets more and more complicated as you start to add people. Page 3, the top of the page, Christopher Moore, who's a great writer on the topic of conflict and negotiation, says that the people in the background, the armchair critics, constituents, are either bureaucratic or horizontal. So bureaucratic, it may be the boss in Zurich, it may be the shareholders in Tokyo in the background. They are in a hierarchy above the negotiator. And horizontal, it may be the brother-in-law, the partner in the law firm, who are in those backgrounds. So I'll give you an illustration on page 3. This was a mediation I was involved in. Could have written several novels about this. My wife often says to me when I arrive back at 1 or 2 in the morning after these mediations, and I'm so hyped up, I have to tell her about events. I say, I could definitely give up this career and become a playwright, because truth is far stranger than fiction in all these cases. It's amazing. So this was an example of a renovation to a factory. The renovation wasn't as successful as hoped. It didn't produce, I've anonymized it, I've called it a cotton factory. It wasn't a cotton factory. It didn't produce the amount of cotton that the owner had hoped for. And so the owner refused to make the last payment to the renovator of $250,000, and the renovator was outraged because his cash flow was tight at that time, and he brought a cross action against the owner of the factory and said, I have suffered damage, I want my $250,000 plus damages, when of course the owner then cross-sued him for about $1 million plus for lost profits because the factory didn't work as well as was expected. So we met, and there was a big group of people and experts, dueling experts, another topic, who met, and everyone had different views on the law, and we negotiated, and it was very noisy. And so we went for a long walk together, just the two parties involved and me. We walked around the suburbs and negotiated and left the supporters in this room. And at the end of the long walk, they had a deal, the owner of the factory and the renovator, and it was a very creative deal. We went back to the lawyers and the engineers, there were about 15 of them in the room, and said, we have a deal. And as we said that, the renovator said, oh, but I can't sign today. Everyone's heart just goes through the floor. So I dragged him outside. What's going on? How come you can't sign today? Oh, I have to make some phone calls, the ubiquitous phone calls. Who to? Long silence. This guy was about 6'8" and was a very tough bloke. He said, my wife. And I said, oh, can you tell me about this? And then I realized as a mediator, I'd failed in my preparation to ask the key questions. Who are the constituents in the background who might criticize you if the deal isn't as good as you'd hoped? I'd failed in my preparation, so suddenly one of the constituents had emerged. Oh, my wife, she's been through a lot of hardship because they didn't pay us the last $250,000. I can't settle. So I dragged him into a room and I said, would you be content if I phoned your wife? And I had the first conversation. Very important, everyone write down there, when you were negotiating with the tribal members, who speaks first to them? Who speaks first? incredibly important as to who tells the story of what's going on. So he said he was quite pleased. Yes, please do, John. You talk to her. So I had my routine as, hello, I'm John Wade, I'm the mediator. I've been working with your husband. He's done a great job. It's been very difficult. So you have to construct the imagery of what has occurred, and that the person who's appeared is a hero. They're not wimps, they're heroes. You construct that, and then you explain to them. And there's all kinds of breaches of confidentiality here. So in the standard format, you would have signed up the wife that she was involved in this. But when you're winging it, you do the best you can. And you say that he's done a great job, and this is the progress we've made, and this is the deal that's we've worked towards, and you may not be as satisfied as you had hoped. This may be disappointing, but we've looked at alternatives, da-da-da-da-da-da. And of course, then you've got the husband standing next to you, and he's listening to every word. You don't leave him alone, because you know what he'll say. Oh, the mediator broke my arm, dear, something like that. So you give the phone, would you like to talk to your husband? Yes, and you stay there, very close to the husband, because you've got to hear his reinterpretation of the story so that you can then correct it all when you get back on the phone. In any case, the wife was able to become reconciled to the fact that this wasn't as much money as they'd hoped, but they got a second renovation deal out of this particular settlement. So that's an illustration of the failure to prepare properly by asking the question, tell me who will criticize you if you don't get a deal which is as good as you'd hoped for, who's in your background. And many people won't tell you that because it's too embarrassing. But you may have to eke that out slowly, because you know there's someone there. The rugged individualist is unlikely to actually exist. And I've done some mediations with some very tough cookies who carry guns, and they still have someone in the background who they have to make the phone call to. And you need to be able to help them with that phone call. All right, so the question that's sometimes asked, bottom of page 3, is, do you have authority to settle? If you put a big circle, 5th line from the bottom of page 3, around authority, that's the weasel word, that's the slippery word, which is not a very helpful word to ask in its blankness there, because the word authority has so many possible meanings. The right answer to that question, just so you know, is look the person in the eye and says, of course I do, subject to the usual limits. That's the right answer. The answer yes is usually a lie or a misunderstanding of the word authority, because no one has absolute authority unless they're real wheelers and dealers and high-flying entrepreneurs. So the meaning of authority, there's multiple meanings. So on page 4, the first possible meaning, someone could come back to you and say, yes, John, I am the CEO of the company. Yes, John, I have an authority from the 3 shareholders. They hold up a signed authority. I have an irrevocable power of attorney from the members of the family to settle this succession dispute. So that's, excuse me, that's great if people have those things, but that's only one form of authority, because they're not saying, and I will settle within a range. I just did a negotiation in a mediation in Vancouver, and that was a professional negligence case, and of course the lawyer just lied. The lawyer who was acting for the professional insurers, he said, oh yes, I have authority to settle, but the claim was for $10 million, and he arrived at the mediation and said, of course I only have authority up to $1 million. So he was playing the standard game. He just straight out lied when he was asked, do you have authority to settle up to the limit of the claim? Yes, answer, wrong. So that was very inflammatory when he arrived, because he just announced, I have authority to settle up to $1 million, and that really devastated the clients who were claiming some kind of compensation. So legal authority is one form. It's a nice form, and it's one you may look for. Particularly, I've used it a lot in succession disputes, where you want to keep the hawks in the family away, and you want the moderates to attend at the meeting with an irrevocable power of attorney to sign up the hawks. But we still have to keep in touch with the hawks. Persuasive authority, that's a great form of authority. This is the insurance adjuster who says, John, I don't have legal authority. I will have to go back to head office, but you need to know that I have a great hit rate with head office. I have done 400 of these claims in the last 3 years, and they have accepted my recommendations in 396 cases. So that's the best kind of authority. That's saying I am an influential person in my tribal group, and I've got some stats to show it. Now you have to be careful of that one because people lie to you and also are overconfident of their own persuasive powers. They go back to their tribes and they get crucified, whereas they thought they were very important. And when they go back and say, do I have a deal for you? And then reasonable outcome authority, page 5. Someone might say to you, yes, I have authority to settle within the market limits or within the usual limits. And so what they're giving you code for is we have made an evaluation of this case and we know what is, then the weasel words, fair, reasonable, appropriate, and I can settle within that range. And the obvious question, what if we go outside the range? Well, I'll have to make some phone calls, John, which is an appropriate kind of response. So probably if someone possibly had all 3 forms of authority, that's great. But be careful of the blank question, do you have authority to settle? It may not give you much information, or it may just give you lies. Increasingly, courts and legislatures are impatient with negotiators who are clerks, who are uninformed about the nature of the negotiations. In other words, the tactical process of sending along a junior to negotiate or sending along a lawyer who's not on top of the facts. So increasingly there are legislative provisions, you'll find them all over the world now, which say it is contempt of court, or it is an offence, or it is an offence against Law Society rules if you don't send someone to the negotiation who has, and then weasel words, full authority to settle. So here's an illustration. Bottom of page 5, I've tried to give you a few of these illustrations. So this is from a Californian ADR local rules for lawyers. A unit or agency of government satisfies this attendance requirement at a mediation if represented by a person who has, and then notice here come the words, to the greatest extent feasible, what does that mean? Authority to settle, and who is knowledgeable about the facts of the case. So theoretically, at least in the world of lawyers, you could report a lawyer for arriving at a negotiation. You could report them to the Law Society with possible sanctions which follow from there if they arrive without knowledge of the facts, if they say, oh, well, I'm not up to speed on this. Of course, some of these legislative attempts are not very effective, but they represent a trend, the impatience of legislators and the impatience of judges of the tactical or management games that are played. All right, the 2 key questions for you as a negotiator, for me as a negotiator, is who are the influential outsiders behind the visible parties, behind the person on the phone, behind the person on the email, behind the person face-to-face, and then how can you manage those influential outsiders? So what are the ways of doing this? And you should work on page 6 just suggests to you, you should work on the assumption that they are always outsiders. That's a more realistic assumption than believing the person in front of you. And certainly cross-culturally, if you work in Japan, if you work with indigenous communities, if you work in France, most of Europe, not Norway, not Scandinavia, you should work on the assumption that the person in front of you does not have authority, and in fact they would look upon you with some scorn if you even ask that question. Do you have authority to settle? Well, because you've asked such a stupid question, I'll say yes. But of course I don't. I'm accountable to a whole organisation, so whatever we agree to here, I'll have to go back to. So be careful cross-culturally in asking this standard question, do you have authority to settle? Okay, so how do you answer this first question? Here are some of the catchphrases on page 7. You've got them both in colloquial forms. You should translate these into Canadian. And also they're expressed in Australian at various places. So as a mediator or a negotiator or a litigator, If you reach an agreement, this is on page 7, if you reach an agreement which is less favourable than you hoped for, is there anyone in the background who might be critical of you? Oh no, John, I'm a freewheeling, multimillionaire, independent, non-accountable person. Oh, I see, thank you very much. Are there any important people in the shadows to whom you'll need to sell the outcome of the negotiation, mediation, litigation? Any shadow people? And these questions may be too direct in some cultures and you're not going to get an answer. Other cultures you'll get a quick answer. Yes, my accountant. Yes, my business partner. Yes, my spouse. And then one, change the language. Do either of you have armchair critics or constituents who are looking over your shoulders? So that's a phrase in Australia that rings a bell with people. Is there someone looking over your shoulder that people understand that? Well, actually, John, there is. And then if they give you waffle answers to that, on page 7 you've got much more direct answers, direct questions. Mary, how will the head of your department feel about a result which is disappointing? So go straight to start hypothesizing. How would your family, how would your partner feel if this was a disappointing outcome? So you can become much more direct when the indirect questions don't lead to a result. It's important to try to identify these constituents because you don't want to be negotiating with these unknown power players in the background. And whether you can then do anything about it is another question, but you definitely need to try to identify them. Okay, so to give you another illustration on page 8, this was a mediation I did which involved a Sikh temple. And it's a wonderful case study again of refugees and people starting their lives again in new countries. So people who flee to Australia first from a persecuted group tend to get MBAs, buy big houses, get mortgages, send their children to universities, become conservative, successful citizens in various means of success. And the next wave of refugees who arrives, of course, they end up driving taxis. They are still embittered from the kind of experiences they've had of persecution in another place. And so they have a sense of loss and a sense of betrayal that their first generation of refugees are now so westernized, successful. And so conflict breaks out inevitably in these communities between what you call the liberals and the conservatives, the first wave of refugees and then the later wave of refugees. And because of Sikh culture, that quickly becomes violent. They've been persecuted, hung by the British. They are accustomed to violence. And so, and Canada has had some episodes of that also. And so in this particular temple, there were fistfights, there were bricks through windows, and the conflict escalated in the Reuben, Pruitt and Kim meaning of escalation. People came to characterize each other as undesirables. They hired lawyers, and the conflict spread to, should we build a basketball court at the temple? Should we be wearing headgear? Should we be sitting on chairs? So it escalated. And so it turned into a massive, what's called Supreme Court action in Australia for dissolving the church, for selling the temple and all that sort of thing, dividing proceeds. So they went to mediation, and of course, who should you bring to the mediation? In these groups, you've got a congregation of 400 or 500, who should you bring along? So you create a committee of liberals, a committee of conservatives, you consult, are these the right people to have at the meeting? And everyone assures you with their hand over their heart, oh, these are the powerful players in each group. And so you end up with 4 liberals, 4 conservatives. That was a funny mediation because on the first day of the mediation, 3 very large men turned up. It wasn't just 4 and 4, it was now 4 and 7. And these were huge guys. And they sat there and said, well, we're not leaving, John. We've seen some of the incidents, so we're witnesses. And so you have to then deal with the question, as a negotiator, what do you do with big guys who look like they do strange things at night with their fists? What do you do with them when they turn up at the negotiation? That's another story. So the negotiations there went on for 3 months, and these people were fantastic, and we reached a very complicated deal. And what happened next? Complex deal about the use of the temple, division of funds, who went to what service at what time, what kids played on the basketball court. Very complex agreement. Okay, exactly what happens in all these complex cases? They took the deal back to the congregation and were crucified. How dare you surrender? How dare you wimps? How dare you give up the principles for what we stand? So they once they brought back the bad news, they were shot, and they came back absolutely crestfallen, saying, "John, it's not working." So the tactic used there was, I said, "Oh well, what if we have a congregational meeting with 400 or 500, and I'll come out and I'll explain to them what a wonderful job you've done, and here are the 4 options we looked at, and this is why we narrowed down to this option." They said that'd be wonderful, it'd be saving face for them, and we may be able to sell it to the constituents. What happened next? Remember, these are experts in conflict. What happened next? The Hawks are expert at destroying all agreements. So we arranged the town hall meeting, and then the phone call came through. There's a bomb in the hall. That's the end of the meeting. The Hawks have won. Goes back to litigation. So Hawks are always smarter than the negotiators. But that was an illustration of where the declaration that we are the key players, that we have authority, that we have persuasive authority, we have legal authority, all turned out to be false. All right, I think I'll come back to this scenario because we may not have time. All right, so having identified some of the influential outsiders, my wife, the shareholders, the CEO, what can you do about it? Page 9. Once you've identified the people on either side, you've got your own client, and then you're guessing that there are people on the other side, what should you do about it? And that's where you need to take out your little bubblegum card. It gives you 13 options, and I would recommend to you that you make some of these your own, of the options of how many shots in your repertoire, how many chips in your golf game. You take a few of these and make them your best shots, and you don't despair when you discover that there are all these armchair critics in the background. So I'll take you through these and see if you recognize some of these from your experience. All right, page 9. The first option, of course, is to say, well, we're not going to negotiate until the CEO is here, back from her skiing holidays in Switzerland. We're not going to negotiate until the shareholders, all 7 of them, are present in the room. We're not going to negotiate until your wife is available for this negotiation. So that's a stonewalling tactic, and it may be entirely appropriate. Next, you may actually turn up and discover that there are some more players here. There is another insurer in New York, a reinsurer who should have been here. So you say, well, we're going to adjourn. It's just a subcategory of the first one. We'll adjourn, and we'll keep adjourning until we can find a convenient date for all these people to attend. And so sometimes you conduct mediations in auditoriums with multiple rules about who can turn up and who can sit and watch, who can listen, who can speak, or using teleconferencing or Skyping to include people at a convenient time. So that option it needs to be in the repertoire. It's unrealistic in many organizations because busy people are not going to turn up to every negotiation, and sometimes it will be resisted because I don't want my wife present, I don't want my husband present, I don't want my father-in-law present, even though he's a key player in the family business, because it's too embarrassing to have to pull the skeletons out of the cupboard in front of this person. I just want to try and fix it up quietly, and then we'll try and sell it to him or her. So adjournment, carry on regardless is a very common one, where you say there's probably someone in the background. I believe there's someone there, or I've been told there's someone there, but we can't get them here present. It's going to be more complicated if they're here. And the other side doesn't like all these extra people turning up. So let's just carry on. And at 4 o'clock, if we get a deal, someone's going to say, oh, by the way, I have to make a phone call. Then there'll be a lot of upset. Why didn't you tell us before? And you'll just muddle through as best you can at 4 o'clock when this all comes up. So that I think is very common. It's better if you know it's coming, if you know the phone call is going to turn up, because it's then not quite as an ambush and you're ready to handle some of the resistance that occurs. Just so you know, because I used to do a lot of family mediation, key outsiders are teenage children. And so what do you do when you're negotiating with the parents, between the parents, and it becomes clear that a 15-year-old or a 13-year-old or a 12-year-old who's not there is a key player in how this will all work? How do you include children, having identified them as key players? Because parents are sometimes really unrealistic. They say, oh, we'll make these arrangements for this 13-year-old. And you think, well, a 13-year-old's not going to do what you tell them to do. They've got to have some input. So you identify the person, then how do you get them involved so that they give some sort of input there? Next, you normalize. The next strategy, having identified the outsider, excuse me, is you say to the people, well, it's quite normal for there to be outsiders. It's quite normal for a CEO to be too busy to attend. They're not playing tactical games necessarily by saying there is a boss in the cupboard, there's a dragon in the cupboard who I'll have to consult at a later stage. They may be playing those games. So you need a number of phrases to say it's quite normal for phone calls to be made. So if you lived in another country, in Japan, in France, as I mentioned, it would be absolutely normal to just have this first round of negotiations to get a framework, go back to constituents, come back for second round of negotiations. Next, on page 13, how do you handle this? You could ask ritualistically the authority question. Oh, before we start this negotiation, I just want to make sure that everyone here, I want to make sure that my clients, I want to make sure that your clients have authority to settle. Could you tell me whether you have authority to settle? So you can ask this question, hoping that it will unearth people in the background or that it will give some clarity. My experience of that question is it usually doesn't give you much information, because people either lie, say yes, or they say yes because they've interpreted authority as meaning I have authority within a range, but I can't go outside the range. I can be fairly non-creative, but once we become creative, I'll have to make phone calls. So that option, which is used by many people, both at law school and in practice, may not give you as much help as you want, but you may still use it in any case. Next, this is an interesting one. Is some people say, well, we can handle this, John, by getting a form of authority signed by the outsiders. They will sign a written authority that the representative can settle this case. So the representative can wave a piece of paper saying, John, I have an authority to settle. Now that sounds good, and it may work extremely well. I've had really good results with that in some situations where they waive an irrevocable power of attorney and say, the sister has given me an irrevocable power of attorney and I can sign off on her behalf, even though she is deeply involved in this, but she's decided to stay away because she gets so angry in these negotiations. The legal authority, this piece of paper, of course, doesn't answer the question, will they sign off? What has the sister said to them confidentially in terms of the range that's acceptable? So it doesn't answer those questions. And of course, any smart negotiator is not going to hand over an authority with numbers on it. I have authority to settle on behalf of my sister between $400,000 and $600,000, because no one trusts mediators, for a start, that they will leak these numbers and with justification, you shouldn't trust mediators in those situations unless you've used them a lot before and they have become highly trusted people in your lives. Because mediators are engaged in all kinds of deceptions, standardly, unless you have come to trust them. So and then if they use weasel words instead of actual words, I have authority to make a fair, reasonable, appropriate settlement. That's told you nothing either. So these forms can be helpful, but they may just lead you back into the wilderness of, well, will this person in front of me actually negotiate with vigour, knowing what are the range of outcomes? All right, so this next one, ironically, is one that I have used a lot, and I recommend that you put it in your repertoire and practice the language attached to it. This is on page 15. You know that the person in front of you, the lawyer, the accountant, the company secretary, whoever is there, probably must account to some outsiders. And you know that they are going to have to go back to the outsiders, like in the Temple case, and try to sell them a difficult package. And you know how the conversation goes. So I sometimes recite this conversation to people. So you see it on bottom of page 15. This is how the conversation goes. The constituents, let's say it's your partner at the accounting firm, says, "Oh, Mary, how did the mediation go last night?" "Well, we reached an agreement, but it's not quite as good as you hoped for." So this is the pattern. "What did you agree to?" "Well, there are basically 4 provisions. I'll take you through those." "Hey, hang on, that doesn't seem very fair. Why did we get so little? Are you," and here comes the weasel word, "happy with that outcome?" Happy. Get the happy word and burn it. "Well, I'm not happy, but in the circumstances." "Well, if you're not happy, why did you sign it?" "Well, it was the best we could do, and the mediator put some," now the blame shifts, "the mediator put some pressure on us to settle." "Well, this is very disappointing. We need to reconsider this. I'm going to phone the mediator and say everything's on hold. It was only a contingent agreement in any case. They must be laughing at us. They've really taken us to the cleaners." Right, so there's a standard conversation that's going to take place when the agent goes back to the principals, goes back to the constituents. It's explain, disappoint, defend. Explain, disappoint, defend. So how can you change the nature of that conversation? And use of best endeavours is one of the ways that I and friends from my university, we did a lot of this. We would use this and talk about it afterwards, debrief on how we had tried, either successfully or unsuccessfully, to use this. So on page 16, you have the conversation with your client or with the clients, if you're a mediator, before the actual meeting, before the Skyping, before the telephone calls, and say again, what if you reach an agreement which is disappointing to your tribal members? "Oh, well, we'll wait and see, John, see what happens." "Well, let me tell you what will happen. I've done this before. You'll go back and you'll disappoint and defend when you tell them what's happened. And they will say it's your fault or it's the process's fault. Could we look at ways at minimising that kind of crucifixion that takes place of you?" "Oh yes, that's a good idea, John. Are there some ways to minimise my crucifixion?" So would you be prepared when you go back to your constituents tomorrow night to make a speech something like this? And you give them an example of best endeavours. We agree that when we go back to our constituents, we won't just say, "Oh, we have an agreement. Oh, it was very disappointing. Oh, we were put under pressure." Rather, we will go back with a speech. "We gave it our best shot. There were 4 alternatives. We looked at the 4 alternatives. 3 of them had more problems than the 4th. The 4th had," and so actually coach them in what they can say rather than a half-hearted disappoint and defend speech. And of course, this is not an infallible method, but it's amazing that once people are primed to reduce their own crucifixion, that they're willing to practice these speeches and be ready to use best endeavours. And particularly if you can get the two moderates from both sides to have this public agreement. We agree that whatever agreement we reach, we will use our best endeavours to sell to our constituents. They've made a public commitment to do this and may honour it. I can think of a couple of examples where people promised to do this and we had the public commitment to best endeavours, and then they immediately wilted when they went back to their constituents and said, oh, it wasn't a very good deal, oh, we got pressured, and they didn't have the strength to stand up to their constituents. Okay, so that's number 7, but I encourage you to think about that, those of you who are involved in negotiations where you know there are tribes in the background. Next one, you get an opinion from an evaluative expert or an evaluative mediator. So you're trying to help the agent who's going back to sell this deal to look like a hero. So I have a friend who's been a mediator for many years, and he happens to be 3rd generation Chief Justice of the Supreme Court in Australia, so father and grandfather and now grandson. And he is a distinguished aristocratic character who works well with the prince and the pauper. And he has a beautiful office, and he has a gold pen, and he has a routine which is just fantastic. And no wonder people hire evaluative mediators. He says to the bank managers, he says to the CEOs who are there and they're reaching the deal, he said, would it be any help if I gave you each a note? And they say, excuse me, and his name's Sir Lawrence. Excuse me, Sir Lawrence, what do you mean? He said, well, I have here, and he pulls out this magnificent piece of parchment out of his drawer, picks up his gold pen. I have a custom where I'm able to say, from my experience being Chief Justice, the settlement that you have so successfully reached is within the range of orders that I would have made as a judge of the Supreme Court. Would that be any help to you? Oh, yes, please, sir. Can I have one of those? And would you like one of those too? Yes. So it's all written in handwriting, nothing typed up with this big pen, hands it to them. They go back, and on their crucifixion, they say to their constituents, look what I've got. Sir Lawrence said this was in the range. So here is one of the benefits of hiring evaluative people. You're protecting the agent, and you ask for the evaluative person to give you the note, to go back, to show to the shareholders, I did my best, and this is in the range, according at least to this particular well-known expert. Now, most of us don't have that kind of glow of authority, so that particular option is not open to us personally, but we may want to bring along somebody in that hallowed category as an engineer, a mining expert, a litigation expert, all of them who cost a lot of money. All right, this next one is what I do. I do particularly, this is 9 and 10, is sort of one of the badges, marketing badges of what I used to do as a mediator. And certainly in diplomacy, certainly what's going on in Ukraine at the moment, you would see this, these kinds of strategies being used. So, having identified who's in the background, I as a mediator say to the parties, I would like to talk to the person in the background. Can you give me authority to do that? Yes. They sign a one-line statement. Will you contact that person and tell them that I will be contacting them? You never want to ambush a third party with a phone call. They must know that you are contacting them. Otherwise, it looks like a setup. And so you phone that person and you have a routine, say, my name is, I'm the mediator in this case. Is this a good time to talk? Bill has sent me an email saying that he has warned you that this conversation would take place. And then I go through the same preparation routines as I do with the parties to the negotiation. Here, remember the 5 humble hypotheses? Can you tell me why this hasn't settled in your opinion? So the third party becomes one of the diagnostic tools. Can you tell me why this hasn't settled? Blah, 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 John, or crazy, blah, 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 blah. You listen to everything, give it back to them. If you were the mediator, you're asking the spouse now, if you were the mediator, what would you do? So you ask the intervention question. What would be helpful to make this work? You'd be amazed what the third parties tell you. Just incredible things. What do you think will go wrong when we meet? You get all their hypotheses on this. So what's the hurdles? What could go wrong when we meet? Next, the risk analysis. And tell me what's the downside if you don't get a deal here. So that you add their insights, you're asking them questions, you're listening, reframing back. And so you've got a whole new construct of how to handle this from the outsider. They have bought in with their information, and then you ask their permission, which goes on to number 10, is you ask their permission, will they be available? Could they be available on the day by Skype, by phone? Could they be available between 3 and 4? I would like to phone them and give them a report. Confidentiality issues there again. Theoretically, you should be signing everyone up to say this is permissible. Can I give you a report on how it's going so that you don't get ambushed, so that you can give some insights into this? So this is extremely important to get them involved, to get their diagnosis involved before you start negotiating, and they feel then that they are important and they have given you key information. Which takes you on to number 10. This is called the decision-making process. So as a negotiator, you lose power once you start negotiating. You lose power once you start negotiating. So you need to make your power moves before you start negotiating. In effect, brinkmanship, this is page 18, number 10, is in effect you say, I will not negotiate, I will not help you, I will not help the client, I will not help the clients unless. And you create some procedural hurdles. So one of the unlesses is to say, we need to have a decision-making rule in each team. You know what's going to happen. The agent's going to go back and get crucified. And they're going to get crucified particularly by the hawks. Every team has hawks. You could have done better. It's a matter of principle. Why didn't you fight harder? You're a wimp. All those kinds of speeches. So you insist as a mediator or as a lawyer, I will not go to a negotiation and waste your time, your money, my time, my money, only to have you go back and be crucified. So each of the teams must have a publicly announced decision method. So to try and make this more concrete, did a church mediation, classic liberals, conservatives split, now become World War III, and two very good and very aggressive lawyers who were despairing on the litigation here. So we met, and I said to both the teams, we're going to have a long night here. This one finished at 4 in the morning, and we're going to have a long night here. When we have a good proposal on the table, I will not go ahead unless each of you have publicly committed to a decision rule. So there's 7, 8, okay? 7, 8. I take them each into separate rooms and say, okay, what's the decision rule when we get to 2 in the morning, when one of your people comes in with a recommended solution? In other words, when the committee of moderates decides this is the least worst alternative, how will you vote? Because you know the hawks will say, stupid idea, wimps. You know the hawks can destroy the deal. So you must have a publicly announced voting rule. In the team of 7, what will it be? You leave them to decide that, team of 8, and you wander backwards and forwards. And you warn them, you've got to publicly announce your voting rule. And the lawyers were very helpful here, because in the team of 8, 2 of those people were paying the lawyers' fees. 2 of the team of 8. So they'd paid hundreds of thousands of dollars so far to the lawyers. So they were the hawks. They had the biggest commitment. So the voting rule, you knew it couldn't, and you say to them, it cannot be 8-0. You cannot have a voting rule of unanimity. I will not mediate if it's, you can't agree which day of the week it is or whether grass is green. So it's not going to be 8-0. So you've got to come back with a rule and public announcement. So they talk. The hawks start to catch on, you see. They know what's going on. Hawks are very smart. They know they're being outmaneuvered early in the negotiations. So they fight for unanimity. It's got to be a unanimous vote. But in any case, I say the mediation's over if it's unanimous. They come back, and the 7 said 5-2, and the 8 group said 5-3. They announced it publicly. This will be the voting rule when we get to a recommended settlement. And early in the morning, the committee of moderates, which had pulled out, came to a package, took it back to their teams, and the votes were predictably, the 2 hawks voted against it, but they had a 5-3 rule, so the vote was 6-2, And then they were able to strut around the room and say, we are honourable men. We will comply with our agreements on the voting, even though we don't agree with the outcome. So 10 is very important. It involves consulting and arranging a decision-making process. Okay, so you've got that all set out on page 18 and 19. How you set up a decision rule within a team and how you brinkmanship. I will not go to the negotiation until this is publicly announced. What is your decision rule? All right, so let's jump up. You've got some, on page 20 to 22, you've got some discussion of confidentiality and a precedent of a confidentiality note if you want to get people to sign up that some of these discussions with the outsiders are confidential. Most negotiators don't do that unless it's in multi-million-dollar disputes and they get nervous. Number 11, if you have outsiders, you must get to them first when a deal is struck. You must not let the parties explain in their language what the deal is. This is one of the benefits of having a mediator, and a good lawyer will do this also. A lawyer will contact the constituents, the relatives, the board, and say, I would like to give a report on what happened at the negotiation. And the lawyer uses his or her language, not the client's language. The language of, we had options, the client worked very hard, you praise the client, you say it was very difficult, you say it was normal, the kind of range that we got to, or the kind of package. And in other words, you give a version of history which becomes the dominant version. Now this is very stressful if you're a mediator, because this means you don't go to bed at 4 o'clock in the morning. You go home and you start typing up the version of what has happened, because you want that to be on the desk of the constituents at 9 o'clock in the morning. You don't want the agents, the negotiators, to go back at 9 o'clock and give their version. You want your version to dominate linguistically, not about we lost, we failed, but rather in the options available, this was why this was a success. So I encourage you to do this. It's very exhausting to get to the outsider first. You have to strategically tell the person that's what you're doing and make sure you don't sleep that night. Next option, you warn the parties at some stage in the negotiation, what if this is destabilized? What if the board doesn't understand? What if they weren't here to experience the pain? So you're just trying to get them ready for this traumatic event. And you're, in effect, warning of some of the downsides of reneging. What if the board puts pressure on you and you have to renege? How will you be able to come back to the table? Will people trust you again? You're trying to, by using number 12, push people back into one of the earlier options. The final option, which I've never used, but I've seen good lawyers use, is to throw a tantrum. Of course, a fake tantrum, not a real tantrum. Real tantrums have got all kinds of problems attached to them. Fake tantrums have also problems. So the lawyer goes, usually it's the lawyer goes berserk in a mild way. I can't believe you put in all this work. I can't believe that we've been here for 12 hours and you have worked through these options and now you tell me you've got to make a phone call. Don't you have the guts to sign this up yourself? And so really go for them or go for them softly and try to shame them into taking the risk that they'll sign up without consulting the outsiders. Now, it could be professional negligence. I've never done it. I don't encourage you to do it, but know that some people will try that with the risks attached to it. So there's the list of 13. In that list, I would say that the ones that I use a lot is 7, 9, 10 and 11. You will have seen in your worlds use of some or all or more of those. Anyone want to comment on what you see regularly or what you see occasionally as a way of dealing with the outside critics? Anyone comment on the worlds you occupy? Yes, please.
I would just say that it's often that you're talking to the influences before negotiation. It's often good if you can get them to suggest what the outcome should be rather than telling them what it is.
Okay.
Yeah. That you may arrive at the same point, but if you can somehow convince them to suggest it.
Great. Okay. So it's Eric, is it? Yeah. Yeah. So Eric, I guess, is on number 9, particularly number 9. If you speak to an outside authority before negotiation, the suggestion he's making is, if it's possible to get the ideas to come from the mouth of the outsider rather than you say what if, that's a very powerful thing, because I guess because you're selling then their solution back in the negotiation, and you have some idea of what would be acceptable in their eyes. So just back to the children illustration, in the mediations I've done where the parents have been coming up with what I think are crazy ideas for dealing with children, and they have authorized me to interview the children, is in that situation I can say to them, well, Mum and Dad have come up with option A and B. Here are the options. What are your thoughts? And they say, well, option A wouldn't work because of basketball, and wouldn't work because of my homework, and option B is crazy because Dad's depressed and I need to look after Dad. And so I say, so what's option C that would work for you? And they have come up with amazing ideas, and I then have to go back with great risk and sell to the parents the proposition that I haven't manipulated the kids as a mediator, that the bad news is options A and B have been rejected, but the good news is they have option C. Would you like to hear option C? And then put option C on the table with the risk attached to that. Others? Charmaine?
When use the explain settlement, like number 11.
Yes.
I'll do it by speakerphone, because then, and I'll say we're all on the speakerphone, and if I'm explaining what's happened, then simultaneously, really, then the client can say yes or
no.
In or no, and the
yes.
person on the phone that can't see the body language or anything, there's, so that it seems less secretive in some way.
Yeah, no, that's because they know that there's a kind of checker in the background of the actual parties who can. Yes.
What I'm saying.
Yes. Okay. So that's a great model too. Okay. So conclusion. In your life as a negotiator for the rest of your life, and you're probably doing this already, we can add value by normalizing. We can say this is a normal feature of negotiations. So what should we do about it? Who are the influential outsiders, tribal members? And say it's normal to have these outsiders. It's rare for someone to be a rugged individual. Who do you think is on our side? Who do you think is on their side? How can we manage this? What can we do about it? I don't know. This is crazy. We'll never settle this. It's all out of control. Well, the good news is there are various ways that people standardly deal with this. And you can pick from your list 4 of them and say, any of these 4, might they work? As I said to you before, it's like selling flavored ice cream. Don't suggest 13. 13 flavors is too many. People get overwhelmed. You probably need to have about 4 that say, these are the standard ones, or these are the ones I use standardly. Would they be any use? And that can add to your repertoire of shots, and people can see that they're normal, they're not bizarre, and this may help them through the jungle. So that's the last of these series, and it's been great to meet you all, and I wish you well in your life as negotiators. Thank you.